Welcome back to the channel and thank you for watching. So every now and again YouTube will limit one of my videos because it thinks that there's one or two words in it that some people won't like, so it limits some of them. And case in point, it limited my first analysis video of the Depp Heard trial, but I would like you to be able to see it without it being limited. And so I've edited certain words out of it and the audio recording out of it. But we all know what's on that audio recording, so you don't need to have that reference to it. But I thought I would show you that video once again here, just in case anyone missed it, and so that it's no longer limited. So enjoy my first full analysis video, one of several analysis videos. So as always, please do let me have any thoughts and comments in the box below. Enjoy. Welcome back to the channel. So as promised, I want to do a breakdown of the UK Johnny Depp trial against News Group newspapers and Dan Wootton, not notably against Amber Heard, which is something of a significant issue because the comparisons are being drawn between the US trial and the UK trial, specifically in respect of Amber Heard. Now, whilst she does centre within the story, of course, with Johnny Depp, she was not a defendant in the UK case. So this video may have to be broken out into two, if not even three videos because of the length of it, mainly because of the length of the judgment. It was 129 pages. So first of all, I want to just outline what the claim was, and I'm going to start with the appeal because permission to appeal was refused, and why that might be, why I think that might be, and some of the difficulties surrounding UK appeals. So first of all, for those that don't know, this original trial in the UK was about an article published by The Sun referring to Johnny Depp, initially at least, as a... The article title was later changed to say that he'd been accused of the same thing. But of course, by that point, once it's published, the damage is done. So on the 27th of April 2018, the initial headline read, "Gone Potty, how can J.K. Rowling be genuinely happy casting Johnny Depp in the new Fantastic Beasts film?" But of course, that title was later changed. Now, as I said, there were two defendants in this case, News Group Newspapers Limited, which ultimately published The Sun, and Dan Wootton, the then executive director, as he was so described, who indeed wrote the article that was then published on the website of thesun.co.uk. Now, there are lots of people online that have raised potential bias and arguments. Now, I'm not going to talk about the factual matrix of that. Safe to say that some people say that because the judge's son worked for Talk Radio, a sister company of The Sun, also owned by Rupert Murdoch, and Dan Wootton also at that time, at the very least, worked for the same place. This along with some other concerns about Amber going to some dinner party and so on. But as I said, I'm not going into those in this video. Rather, I'm going to look at the judgment and issues that I take with this judgment and that I've read that other lawyers take with this judgment and go through those. But again, as I said, I'm going to start with the appeal first of all. So naturally, because permission to appeal was sought, there are two judgments. The condensed appeal judgment refusing permission to appeal and the more substantive judgment from the original trial. The appeal judgment does refer to some of the contents of the original judgment, but not all of it because it was so lengthy. And in fact, it says so. It's important to note that in the United Kingdom, appeals are pretty rare in the grand scheme of things because permission to appeal is not granted lightly. The hearing of appeal is limited to a review of the decision of the lower court, and ordinarily it will not receive any oral evidence or evidence that was not before the original lower court. When deciding an appeal, the appeal will be allowed where the decision was wrong or unjust because of a serious procedural or other irregularity of the lower court. But this didn't even get that far because permission to appeal was refused. Now, this is because if part of the appeal is simply to raise questions of fact and not errors of law or procedure or some other substantive ground of appeal, then the appellate court is not going to grant permission because it doesn't want to overturn a judge's findings of fact purely based on factual questions, unless, of course, there is substantial new evidence that does change the circumstances. But as I said, the starting point is that the appeal court is not going to hear new evidence. The test for permission to appeal is that there must be a real prospect of success or some other good reason for the appeal to be heard. and this again is normally based on errors of law, errors of procedure, or that the decision was plain wrong in terms of the law that it applied. But again, as I said, the court is not going to look to overturn a judge's findings of fact purely on that basis of questions. Jumping straight to the conclusion for the judgment of refusing permission to appeal, the court said we would accordingly dismiss both Mr. Depp's application for permission to adduce further evidence and his application for permission to appeal. As we have said, it is not easy to persuade this court to overturn the findings of a trial judge on purely factual questions. We do not believe there's a real prospect of it being prepared to do so in this case. So then I'm going to turn to the substantive judgment and say that many lawyers have observed that there are a number of inferences drawn by the judge and assumptions made. Now, whilst this can be normal throughout judgments, the amount and the degree of assumptions and inferences made and drawn without, as some lawyers put it, full judicial reasons, it does raise cause for concern as to whether the judge simply took Amber at her word whilst discounting other evidence throughout the trial, without any real substantial reason for doing so. So whilst no lawyer will be quick to criticise a judge, I'm going to go through some of the things that gave me cause for concern, and probably for this video starting with the credibility issues that have been raised about Amber Heard and her evidence, which I feel should have raised a significant concern as to the credibility of her evidence, which were ultimately dismissed by the judge. So I'll go through them and explain some of them using bits of the judgment itself, and you can let me know in the comments for each of these things that are raised whether you think that this really does raise significant concerns as to her credibility, as to whether she should have been believed throughout this trial. So just so that you know how this generally works, a judge will hear the evidence of both parties and often say, I prefer the evidence of X or Y party, as a way of giving reasons for their decision. So they will hear the evidence of both sides and they will very often say, I prefer the evidence of this party because gave the evidence clearly. It was backed up by other factual evidence, other forms of evidence which corroborates their account and therefore more believable. Things that should ordinarily go against a party are prior dishonest statements, prior bad character, prior convictions, or anything that generally calls the credibility of that person into question. For example, if somebody is prepared to lie to an authority or a person in authority, this would ordinarily be something that would go against a person's credibility and therefore they should be less believable. There are some arguments as to whether this is a related or connected or tangential issue which is so far removed from the issue in question that it shouldn't have an effect on their credibility. But generally speaking, if someone is found to be prepared to lie to an authority, generally they should be taken to be less credible. And finally, just before I move into that analysis of these credibility issues, I just want to highlight that the difference between the way these trials were heard in the US and the UK are significantly different. In the US, of course, it was heard by a jury, so all members had to be convinced unanimously, having heard all of the evidence, together with the differences of evidence which I explained in my previous video, i.e. Amber Heard was the defendant in the US trial and subject to disclosure, or as they call it, discovery, whereas she was not subject to the same strict rules in the United Kingdom because she was not a party to the claim. So any claims online that she won or they won in the UK, in my view, are not accurate because she was not a party to the claim. Whereas, of course, in the UK, it was heard by a single judge, although there is a provision within the Defamation Act 2013 under Section 11 where it could have been heard by a jury in the UK if the court ordered so, because the default position is that it is not heard by a jury unless the court orders otherwise. So it's my personal view that a case of this magnitude and significance should have been heard by a jury, but ultimately it landed on the lap of one single judge. So moving to the first issue of credibility against Amber Heard, that being of Savannah Macmillan, who was said to be her assistant in the UK, and the argument was as to whether or not she was unlawfully working as her assistant in the United States, and specifically relating to a letter dated the 28th of September 2014 that was sent to the Department of Homeland Security in the following terms. My name is Amber Heard. I'm a proud lawful American citizen. I'm writing this letter in response to a fraudulent report made against my English friend Savannah Macmillan. It has come to my awareness that while spending time visiting me in the United States, someone made a false claim against her, stating without any proof or corroboration that she was unlawfully working for me. As her friend, I can say truthfully and unequivocally that this allegation is entirely false. It was clearly made from the safety of anonymity in order to satisfy a personal vendetta. This allegation absolutely bears no merit, worth, or truth. I would like to go on record as saying that Savannah Macmillan is a personal friend and to my knowledge has never worked unlawfully or otherwise in the United States, or for me. I regret that the precious time of our immigration agencies has been on such a petty personal matter, made out of malice, not truth. I would like to request that this fraudulent report be removed pending the confirmation of its baseless and false stance. I expect the same standards that we hold as pillars in our great justice system. Be allied, as it was written, to immigration policies as they serve at the forefront in representing the United States and her values. Since I expect further investigation to reveal the statements made above as true, I hope that your agency will see to it that no further inconvenience will befall my friend in her attempts to continue discovering our beautiful country. Thank you for your time. And signed, Amber Heard. Now, this letter was said to be a lie because Savannah Macmillan was working in the United States as Amber Heard's assistant. Now, this was confirmed by Kate James, who had been Amber Heard's assistant in the United States. She said in her witness statement that the letter from Amber Heard falsely claimed that Savannah was just a friend and not an employee. Now, Kate James also appended to her witness statement a check made out to Savannah Macmillan for $1,625. Some might take the firm view that Kate James would be in the best position to know whether Savannah was working for Amber Heard as her assistant in the United States, and secondly, that because there was a check attached to her witness statement would also prove that she was being paid by Amber Heard as her assistant in the United States. However, in response to this, Amber Heard said, "Since Savannah did not have much money, I occasionally gave her money." And as you can see here, accepting that she would often refer to the money she gave to Savannah as payments, although trying to explain that away by saying it was to minimize discomfort and embarrassment to her for receiving the money, and that they were partly for expenses like shopping and errands. Personally, I don't accept this excuse. But ultimately saying that she wasn't working for her in the United States. Now, if you take the view that Amber Heard did lie to Homeland Security in this letter, that would be a significantly serious issue against her credibility. However, the judge in this trial simply said at paragraph 112, "I'm afraid that I did not find Miss James a satisfactory witness. She had been dismissed by Amber Heard in February 2015, and the circumstances of her termination still appeared to be the cause of rancor with Miss James." Now, in other words, the judge didn't believe Miss James because she'd been fired by Amber Heard, despite the fact that she attached to her witness statement a check made out to Savannah Macmillan, which on most people's assessment would be some kind of proof that that was in fact the case. Now, just as a sideline, this also goes against one of the judge's way of approaching the evidence in this case, in that the judge said that someone coming to court to give evidence under oath made them a more reliable witness. So applying that approach, Kate James really should have been believed. Another sideline regarding this letter is at paragraph 114 of the judgment, which the judge describes as a subsidiary issue which was addressed by Mr. Sherborne in his closing speech. That being that this letter contained two different spellings of Savannah Macmillan's surname. Mr. Sherborne submitted that Savannah was unlikely to have made these errors herself, both of which were inconsistent with the spelling of her surname in the email address that she seems to use. Mr. Sherborne further observed that Amber Heard had spelt Savannah's surname in a similar way in relation to Amber's prosecution in Australia for bringing dogs into the country illegally, which is something else I'm going to come back to. So all in all, I find it difficult to accept that the evidence taken together with the check made out to Savannah Macmillan could be discounted to come to the conclusion that she did not work for Amber Heard in the United States. My personal view, and you can let me know yours in the comment section below, is that she did work for Amber Heard in the United States. That's my personal opinion. And if that is the case, then Amber Heard did lie to Homeland Security, and I think that's a significant concern. However, at paragraph 115 of the judgment, the judge says, while there may be some force in Mr. Sherborne's observations, in my view it takes the matter no further. Whoever drafted the letter, it had been signed by Amber Heard, and thereby accepting responsibility for its contents as she accepted in her evidence. So again, as I say, I don't know why Mr. Sherborne's observations didn't take the matter any further. I personally think it should, but I'm not the judge. So now to the second issue, which was the issue of importing dogs into Australia, which the judge deals with from paragraph 116. Coming straight to the point, at paragraph 126, the judge confirms in his judgment that this offence to which Amber Heard pleaded guilty involved knowingly making a false statement, and as Ms. Macmillan said, this was not a trivial offence. But in this paragraph, the judge says its nature is so far removed from the evidence which Ms. Heard gave in this trial that its relevance for her credibility is marginal at most. Now again, I call upon you to leave your comments and thoughts in the box below, because in my view, lying to an authority about illegally importing dogs into a country is relatively serious, and she pleaded guilty. And whilst there is much more to say about that, I'll move on to what's described as a more significant allegation, that being that Amber Heard tried to get false evidence from Kevin Murphy and Kate James for the purposes of the criminal proceedings against her in Australia. When making arguments about this, as described at paragraph 128 of the judgment, Mr. Sherborne relied on a series of emails between Amber Heard, Carl Austin, which is Amber Heard's entertainment lawyer, Marty Singer, and another one of Johnny Depp's lawyers. So again, I'll read you the contents and you can let me know what you think in the comment section below. This is from paragraph 129 of the judgment. On the 9th of October 2015, Amber Heard wrote to Carl Martin and Marty Singer in respect of these dogs, remember, as follows. The only thing we are missing is evidence of the process being initiated, however not completed, and therefore the dogs weren't taken on the trip. That is obviously harder to prove since it involves documenting something that didn't happen. However, since I know we attempted to bring them at least once before the Australian trip, I can ask Kate to include that in her statement if that would be helpful. On the 11th of October 2015, Amber Heard wrote to Kevin Murphy, forwarding that email chain and saying, "Kevin, what do you think? Could you possibly reach out for us? Do you think you could get her to do it?" On the same day, Marty Singer wrote an email to Amber Heard saying as follows, "I don't know what your relationship with Kate James is at this time since you fired her. You have to be careful that she'll cooperate and will not go public if you ask her not to be truthful." Now, on any assessment of credibility, trying to get someone else to make a false statement in and of itself is inherently dishonest and should impinge someone's credibility. However, at paragraph 134 of the judgment, the judge says, "I had no evidence that Kate James was, in any event, actually asked to sign a statement of any kind, and in any event, no evidence that she was asked to sign an untruthful statement." In other words, regardless of whether there was any pressure from Amber Heard to make a false statement, she wasn't actually asked to sign a false statement. And whilst Kevin Murphy said in re-examination that he refused to ask Kate James to make a false statement, the fact that he did make a false statement in the Australian proceedings under pressure from Amber Heard, the judge in this case said that is not an encouraging starting point for the submission that his evidence is now to be believed. And then goes on to say that I do not accept that Amber Heard sought to pressurise Mr. Murphy into making a false statement for the Australian proceedings, and accordingly I do not consider the allegations regarding either Kate James or Kevin Murphy impinge on the credibility of Amber Heard. So in other words, it seems to me, and I'd be interested in your comments below, it seems to me that because Kevin Murphy was willing to make a false statement in the Australian proceedings, that made him less credible in saying that it was Amber Heard that pressured him to do so, even though there was an email exchange written by Amber Heard, which I'll repeat for emphasis, where she says that is obviously harder to prove since it involves documenting something that didn't happen. However, since I know we attempted to bring them at least once before the Australian trip, can I ask Kate to include that in her statement, if that would be helpful? And then again in the other email I referred to, do you think you could get her to do it? And if you are in any doubt about that, the third email might be useful from Marty Singer writing to Amber Heard saying, "You have to be careful, she will cooperate and will not go public if you ask her not to be truthful." Now again, there is more discussion within that section of the judgment, but personally I take the opinion that if Amber Heard was forcing someone to make a false statement and trying to get someone else to make a false statement, that should have impinged on her credibility. And let's not lose sight of the fact that this was an offence to which Amber Heard pleaded guilty. But yet again, and despite all of that, the judge came to the conclusion that this did not impinge on her credibility. Another one that I'll deal with fairly briefly was in respect of trying to grease, the term was used, a vet to procure necessary documentation for said dogs. Again, this pertained to an email from Kate James exhibited to her witness statement received from Amber Heard dated the 21st of September 2013, which read as follows: "Can you maybe help Kevin procure a slightly altered health doc that has their shots recorded as 2 days before so they can all leave together on the 25th? Do we have a vet we could grease? Connection? In response to this, in her fifth witness statement, Amber Heard says this was Johnny's language, not hers, thus effectively blaming Johnny Depp. And again, although there was an email from Amber Heard on the face of it appearing to be dishonest, the judge, once again at paragraph 153, came to the conclusion, I take Amber Heard's denial that it originated with her as final. It does not, therefore, impinge on her credibility. Just one more that I'll talk about in this video before I cut it so that it's not far too long are the audio recordings, which I personally think are very strong evidence. Audio recordings are normally strong evidence because if you want to hear what really happened at a certain time, despite someone's evidence in court, the audio recordings are generally the best way to go. Just before talking about this, I will tell you a very brief story without any detail to compromise confidentiality. But in the case that I was involved in, there were significant amounts of witness statements and an audio recording. The audio recording was in stark contrast to the witness statements, and in that case, the judge did hear the entirety of this audio recording and took that as the truth of what happened, cutting through all of the evidence in court, all of the written testimony and the oral evidence given on oath in court. The audio recordings told the true story of what really happened. So paragraph 175, the judge concluded, in my view, no great weight is to be put on these alleged admissions by Amber Heard to aggressive behaviour, and justifies it by saying a witness giving evidence in court does so under an oath or affirmation to tell the truth, the whole truth and nothing but the truth. Questioning can be controlled by the judge. Questions which are unclear can be rephrased. If a question is not answered, it can be pressed subject to the court's control, and if still unanswered, may be the proper subject of comment. None of those features apply to these conversations which, in an event according to Amber Heard, had a purpose or purposes different from simply conveying truthful information. In other words, because these audio recordings weren't given by a person under oath in court giving evidence, they are less reliable as to what actually happened. Now, whilst we're all familiar with the rules of hearsay by now, which is a statement not made in oral evidence, which is truth of a matter stated, as I said, I maintain the view that audio recordings do show you exactly what happened. And in my personal view, this is evidence that she was being aggressive and violent. I personally believe these were admissions of violence. I personally believe these were admissions that she was the one being Johnny Depp. But as I said, I'm not a judge, but you let me know your thoughts and comments in the box below. If you're still with me, thank you for listening thus far. Please like the video and subscribe. I will be back. There is more. But in the meantime, thank you for watching.